When the New York City police moved in and took the tents and sleeping bags from Occupy Wall Street, there was a claim by Mayor Michael Bloomberg that tents and camping are not free speech. And that is just not true. The Supreme Court has ruled several times that free speech is not confined to the oral or written word, that a thing or an action can be free speech, a thing like a black armband, an action like burning the American flag. The Supreme Court has also ruled several times that a public area, even if it's privately owned, like a shopping mall, a business district, or Zuccotti Park, where the Occupy Wall Street protesters are, still have to adhere to the constitutional protection of freedom of speech. So most Supreme Court rulings support the Occupy Wall Street protesters and their right to protest in Zuccotti Park, except one, and it's a big one, because it specifically deals with camping as a protest. It was the landmark case of 1984, Clark versus Community Creative. Community Creative was a protest group that wanted to camp out for a week on the National Mall to protest the plight of the homeless. Interior Secretary Bill Clark wouldn't grant them a permit. The Supreme Court ruled 7-2 in favor of the Interior Secretary, and it stated that free speech is subject to reasonable restrictions of time, place, and manner. Basically, the Supreme Court ruled that the cost to the National Park Service and the Washington, D.C. police was too high. And since the group had other means of protest, their free speech rights were not violated. I've said all along that when we look back on Occupy Wall Street, it will be known more for the Supreme Court ruling to come than for the protest itself. But the group and its attorneys are going to have a difficult time getting past Clark versus Community Creative.